The government is the largest litigant across all courts, and this is something that sitting Supreme Court judges and former Supreme Court judges have spoken out openly in saying that at least 2.5 crores of the 5 crore pending cases are the government's own. So I think the real question is, why is the government the largest litigator, and why is it continuing to be the largest litigator in the country? This is something that the report does not bring up at all. At least 2.85 lakhs of cases are pending by the Ministry of Finance alone. On the one hand, you have the legislature and the executive wanting to over-criminalize and punish people even more harshly than it has before 2010. On the other hand, you have a document like this coming out by the Supreme Court saying we have such a high pendency rate. So you want to punish citizens and you want to criminalize and arrest people and put them in prison, while on the other hand, you have a backlog of cases that you cannot clear for even 500 years. So it seems like the three arms of the government, the legislature, the executive and the judiciary, are not in sync with what they want to accomplish. Because the one thing that the rule of law and a democratic society guarantees is certainty, that if I approach the court even as a litigant, or I am at the receiving end of, say, a summons from a court, in both cases I need to have a certainty of when I can expect an outcome so that I can get on with my life. Unfortunately, this is not the case. Typically, we see that it takes the judiciary about 5 or 6 years to really call out an investigation agency in saying that the evidence was faulty, or the investigation is not the investigating officers are not serious enough, etc. And I think the fact that it may take 6 years for a court to answer that in a specific case is also the problem. Why can't they ask those very same questions the day the case is brought to them on their table, so it never has to enter the docket?
Here in India, in terms of jurisprudence, we recognize that custodial interrogation is justified. It's a justifiable practice of investigation. So therefore, a host of people are arrested, even while the investigation is in its very initial stages. And each such arrest is a file. It's a new case in the already overburdened judicial system. Each such arrest would result in a case before the magistrate, possibly in several rounds of bail applications, interim bail applications, etc. And this is unnecessary. They've been collected right at the start of the investigation process. You can drag in anyone arbitrarily, and you can keep them there for prolonged periods of time. So of course there is an overburdening because of this also, because you're stretching definitions of what constitutes offences.
And having judges belonging only to, for instance, upper caste and who are only male, highlights a certain type of ignorance by the government and the judiciary. A diverse courtroom means more fairness and better justice. For instance, having a woman on the bench brings a very different perspective to a case that a man will not be able to bring to that same case, because a woman's experiences of the world are an essential part also of courtcraft and of what you bring to a judicial mind and what you bring to judicial decision making.
Because now the offences are overbroad, I think, and ambiguous, and there's a lot of discretion uh, in deciding what is an offence, who's constituting an offence, who is an accused, that the lack of diversity would push only a certain kind of people into the criminal justice system. Only a certain kind of people would be looked upon as suspects, as troublemakers, as anti-nationals. I think for this reason also, we need much, much more diversity in the criminal investigating system and the prosecuting system and judges. If there are judges who've also participated in protests, who understand uh, the politics of dissent, then they would not look at protests as something to be scared of. They would not treat protests as necessarily unruly.